Cabinet is expected to discuss legal advice compiled by the Department of International Relations and Cooperation on the warrant of arrest issued by the International Criminal Court for Russian Federation President Vladimir Putin over alleged war crimes in Ukraine, as it will affect the possible visit of the president to South Africa later this year. Pretoria, as the chair of BRICS, has invited President Putin to attend the summit in August. This is not the first time South Africa finds itself in this situation. Solly Mapaila of the SACP has also weighed in on the ICC's warrant of arrest against the Russian President Vladimir Putin. He says it has no binding effect on South Africa. He says the SACP will welcome Putin if he visits the country.
The ICC's nonsensical warrant against President Putin, it's immaterial. It cannot be, it has no binding effect on us. The ICC did not go for people who killed the people of Yugoslavia, the Americans. They did not go for the people of America who killed the Iraqis people. When they invaded Iraq, they created an impression that they are weapons of mass destruction. They didn't find none. Yet the IEC has not issued any warrant of arrest against any U.S. president. Gbagbo was arrested here in order for the French government to still take cocoa to determine the price of cocoa in the world market, which they don't produce. It's produced largely in the Ivory Coast. So they humiliated President Gbagbo and his wife through the warrant of arrest exercised by this criminal entity of imperialism, the ICC. It has no credibility whatsoever. Of course, the problem has been that African countries or developing countries, when they saw any other instrument that can limit the abuse of power, they thought they could go for it. But we have seen that this institution is actually a creation of imperialist forces who do not even belong to it. The Americans do not belong to it. By the way, even President Russia has not signed the Rome Statute, so it's not binding. And to think that South Africa will be foolish to try and arrest President Putin, I mean, really, are they mad? I think that thing, it's immaterial. It cannot be exercised. On the contrary, we will be organizing and to welcome President Putin in South Africa as progressive forces in order to strengthen the new international world order.
Legal expert Advocate Michael Osborne joins us now to share his views on the matter. Very good evening to Advocate Osborne. Thank you so much for speaking to us. I'd like to juxtapose the current situation that South Africa finds itself in. As you heard from the SACP General Secretary, Solly Mapaila, that this is not the first time. But I want to look at what happened when the ICC issued an arrest warrant for then President of the Sudan, Hassan al-Bashir. South Africa had to contend with two separate treaties, the Rome Statute of the ICC and the AU, as South Africa was playing host country at the time. Is this a completely different situation?
No, it's not completely different. It's similar in many respects. The crucial fact is that in both cases, Mr. Omar al-Bashir and now Mr. Putin, both of them are sitting heads of state. And the argument will be raised whether, whatever you might think of the potential liability of other people, heads of state on diplomatic missions should be granted immunity from protection. And that's the argument that's going to be made.
Now, in the past, borrowing from what happened with the Hassan Omar al-Bashir incident, we actually saw the opposition parties, or particularly the DA, go to the Supreme Court and try and appeal South Africa's decision. And I know then and now that those who were raising the issue of the interpretation of international law, particularly Section 98, subsection 1 in South African courts. And if we could look back at the Supreme Court of Appeal then and the al-Bashir saga, what were the arguments?
Well, the argument was in part what I've already described, the debate about the immunity of heads of state. And the Supreme Court of Appeal found that Mr. al-Bashir would not enjoy head of state immunity given the nature of the crimes with which he had been charged. The crimes that are centrally within the jurisdiction of the ICC are genocide, wars against, crimes against humanity, and war crimes. Now, if credible allegations are made that a head of state is guilty of any of those three, he or she does not enjoy head of state immunity. So it was found it has been found in various international tribunals, and it was also held to be the case by the SCA in the Bashir case.
I guess what I'm trying to do is look particularly at the legal aspect, because I remember then the arguments that were made was that South Africa as a sovereign country has its own national laws, and therefore international treaties would be subservient to national legal statutes. And there were those who were arguing that as a signatory to the Rome Statute, for instance, South Africa is obligated to, for instance, carry out arrest warrants issued for heads of states even who are in the country. But I'd imagine that it's quite a complex situation. So what are the methodologies in determining the interpretation? What are the methodological tools on how to interpret and identify what should be international law, what should be domestic law, and what supersedes what?
Yes, you put your finger on the crucial question there, because we recall from the al-Bashir situation that he was visiting for purposes of the AU summit in Johannesburg. And as part of the accreditation for people to come from around Africa, the South African government granted them, or attempted to grant them, some kind of de facto immunity. And the argument was then made before the Supreme Court of Appeal that executive provision of de facto immunity should override the more general obligations under the Rome Statute. And the SCA said, no, that's not the case. That South Africa's international obligations under the Rome Statute, which have been domesticated, to use the term, under the Rome Statute Act of the South African Parliament. If you take those two together, the international obligation and the domestic obligation created by the Implementation Act, they entail that the ad hoc immunity granted for purposes of the AU meeting did not apply. Now, one can imagine a precisely similar debate unfolding with respect to Mr. Putin in August. One assumes that it's possible that the South African government may wish to grant legal protection to the BRICS people coming. And that's problematic because of the al-Bashir precedent, which is the only precedent we have, and it happens to come from the Supreme Court of Appeal.
Now, as you heard the SACP General, Solly Mapaila, describe it as progressive forces are looking forward to and will welcome with open arms President Vladimir Putin's arrival in South Africa. We've had the International Relations Minister saying that South Africa is concerned about the situation of the people in Ukraine, but as we know, that it has resolutely taken a non-aligned stance on this. So, people tend to bring it down to their own political ideologies. So, can the Constitution be leaned on here? If we're told as South Africa that we have the most progressive Constitution in the world, our interpretation of what the Constitution compels us to do, will that unite people then around the legal interpretation of how South Africa should react to the situation?
I don't think I can speculate on how domestic alliances in South Africa will respond to the potential crisis. What I will say is that there's been an effort in the Implementation Act, meaning the act that sets out how an ICC warrant must be processed. That has been set up in such a way so that there is no political intermediation in the case of the implementation of an ICC warrant. What I mean by that is that the request will come in from the ICC that an arrest be made pursuant to the decision taken on March 17 that Putin should be charged. So that request comes in, and it comes straight to the Director General, of Justice. It doesn't go to the Minister of Justice. It doesn't go to the Minister of Foreign Affairs. It goes to the bureaucratic head of the Department of Justice. The Director General then is obliged under the Act to refer the request to a magistrate. The magistrate must then hold a short inquiry, which has nothing to do with whether the charges have any merit, but whether all the T's have been crossed, and so to speak. There's a purely kind of administrative discretion which will be exercised, and in principle, then South Africa will then, or the South African government will be obliged to give effect to the magistrate's determination. And that determination, as I say, is a purely procedural one. It has nothing to do with the merits of the case.
All right. Thank you so much for your time, legal expert, Advocate Michael Osborne, speaking to us about South Africa seeking legal advice on the ICC arrest warrant for Russian President Vladimir Putin, who, as you know, is invited to attend the BRICS summit here in South Africa.